Hear ye, hear ye, hear ye. All parties having anything to do before the Honorable First Justice Beverly Canoni, now sitting in the Norfolk Superior Court within Fulton County and Norfolk, brought near to your pen, shall be heard. God save the Commonwealth and this good court, and the proceeding court now set.
Yee, yee.
Second Commonwealth versus Karen Reed. So identify yourself, starting with the Commonwealth.
I'm running for the Commonwealth, Captain.
Good afternoon, Mr. Actually, you're in our spot. Good afternoon, Mr. President.
Good afternoon, Your Honor, Robert Weinberg on behalf of Karen Reed, who sits to my left, and co-counsel David.
Good afternoon, Mr. Weinberg. Good afternoon, Mr. Jay. Good afternoon, Mr. All right, Mr. Weinberg, I will hear you on your motion.
Thank you, Your Honor. May I use the podium?
Of course.
Thank you.
Bev looks so happy to be back. She's like, all right, let's get this party started.
Judge, there are two central issues.
Don't know if there's a microphone.
You would think that they would have a microphone.
If I could ask you to keep your voice up.
Here we go. Keep your voice up.
I just want to make sure I hear.
How many times do you think Bev is going to yell at people to keep their voices up?
Thank you, Your Honor. There are two central issues that are raised by the motion to dismiss and the supplemental affidavits that have been filed on behalf of Ms. Reed. The first of them is whether or not, where there's strong and I contend uncontradicted evidence that the jury reached a unanimous decision, even if it wasn't formalized into a vote or into a polling announcement to the court, but it's strong and uncontradicted as a result of the juror declarations that were made through counsel to the court, sworn to by counsel, that the jury reached a unanimous verdict on 2 of the 3 counts of the 3-count indictment. So the legal issue is in the face of that evidence, whether or not Ms. Reed can again be re-prosecuted for the same offense by the same prosecutor who we contend failed to prove her guilt to even 1, much less 12 jurors in trial 1. And when I address that, Judge, I will make a proposal to Your Honor that's close to the procedural pathway used by other judges in cases similar to this, in terms of just how do we transform representations in attorney affidavits into hard proof that we believe will convince the court, and in fact believe it will convince Mr. Lally in the district attorney's office that jury, the jury that Your Honor described as an extraordinary jury, reached a decision that will be consistent with their jury service and consistent with respecting that jury service, that we give at least the jurors who are willing to appear before the court anonymously the opportunity to inform the court that this was a final unanimous decision. It didn't get further deliberation. It was a unanimous decision on 2 of the 3 counts, and the impasse was in fact on the 3rd count, which was count 2, and lesser includes the manslaughter count. The second of the legal issues that I want to address, and they both together center on the double jeopardy clause, its unique history, and it's discouraging, if not deterring, if not prohibiting second trials when there's any rationale that would justify the verdict of the first trial, the first jury, or the continuation of the first jury's deliberations, is whether or not, now that we have evidence that the jury was not at an impasse, evidence that was not known to Your Honor at the time that you ordered that they be disbanded and ordered the mistrial, evidence not known to Mr. Lally and the prosecution or the defense, that in fact the note they wrote to Your Honor after the Toohey charge on July 1 was not unambiguous, as Mr. Lally wrote in his pleading. It was ambiguous. It was subject to 2 constructions. One, that their impasse covered all 3 counts, and therefore would lead ineluctably to a mistrial declaration, or 2, that the impasse was on 1 count with multiple lesser included charges, but did not encompass counts 1 and 3. Your Honor didn't know what was in the jury's mind, what was in their mind when they authored a note to the court. Neither did counsel. But the issue now, and again, it's in the context
kind
of
of
double
tiptoeing
jeopardy,
around
which
Bevis
is such
names.
a historic and important clause that was enacted by our founding fathers to give them some protection against the sovereign at that point, the king, against simply choosing to mistry prosecutions that weren't going well. And the founding fathers wanted citizens not to have to face re-prosecution. They understood the ordeal and anxiety and risks of having to prove to a second jury what they had proven to a first jury, which is that they were not guilty. And so the real issue here is legally, what do we do when we now know that jurors are declaring to the court that they believed they reached a verdict of not guilty? What can we do on August 8th, if I've got the date correct? 6 weeks after the July 1 trial that Your Honor presided over, a lengthy trial with an exceptional jury. And I contend, Judge, that we can't just accept a fiction that the jury was at an impasse on all three counts when four jurors are saying to you through counsel they were not, and a fifth juror is saying to counsel indirectly they were not. We have to embrace the fact that these are now facts. Yes, they come after the end of the trial, but it doesn't mean that there's not some procedural pathway to integrate those facts into Your Honor's decision-making. And the second one, the manifest necessity issue, has got a lot more SJC and Supreme Court guidance. It's been the subject of lots of cases. We're walking a little bit down a pathway that has some precedents about jurors and they're being reconvened, but it doesn't have the clarity of the precedents regarding the manifest necessity standards, guidelines, principles that we'll address second. But here what we know is that four jurors reached out to defense counsel. Jurors A, B, T, and E, I think is the way they've been described by Mr. Jackson, who received calls from three of the jurors, and Mr. Yannetti, who received a call from one juror and talked to somebody who himself or herself spoke to a fifth juror. We also have the corroboration, not just internally, where these four jurors are essentially saying the same thing. We reached a decision. We didn't announce it. Some said we felt bad about it. We didn't know what to do. But they're internally consistent and not self-contradictory. And that makes them more trustworthy. They corroborate each other. And I contend that the voicemail left on Mr. Lally phone, which he responsibly shared with counsel and shared with the court,
After the fact.
essentially saying this was probably one of the four jurors, but we don't know for sure, said essentially the same thing. We reached a decision that Ms. Reed was not guilty. Murder, the most serious charge that can be brought, a charge that would imperil her the rest of her life if there was a conviction. Other jurors tried to reach the prosecutor. They didn't succeed. The prosecutor made a decision that he couldn't promise anonymity, which every juror seems to want, and that's understandable given the level of media and public attention on this case. And I understand the court gave them discretion, and Your Honor made an order that the defense didn't dispute that they were entitled to anonymity. The public interest did not weigh the interest of the jury in anonymity. But we now have the declarations of the jurors through the defense counsel. We have a voicemail of one juror through Mr. Lally. We have emails of other jurors who only wanted anonymity as a condition precedent to talking to the prosecutor. This case, because it has catalyzed so much publicity, it's plausible to believe, if not compelling to believe, that other jurors who sat through so many weeks of testimony, this was probably one of the monumental central events of their life. Not many people, certainly not people who go, other than people who go into military service, have opportunities to serve their community like these jurors do. Not one of them, to our knowledge, has picked up the phone to defense counsel and said, those jurors that you're memorializing in affidavits and in motions, I don't agree with that. No one has called the district attorney. Nobody has emailed anybody. Nobody has called Your Honor through the court clerks. Nobody disputes, in other words, none of the 7 or 8 jurors that are not
It's true.
represented by the series of affidavits of defense counsel dispute the truth of the representations made by counsel. We don't have certainty. We only have the reasonable inferences from the absence of other declarations, which is that this jury was unanimous in its acquittal of Ms. Reed on counts 1 and 3. So then we get to the legal issue, and again, as I
Like how he's breaking it down.
to say, the legal framework here, the landscape is not quite as crystal clear as it is in the standards of manifest necessity, whether or not double jeopardy permits a re-prosecution in the context of this unique case. But what we have is court decisions saying, for instance, what constitutes an acquittal is not to be controlled by the form of a judge's actions. We're not bound by labels. That's the SJC in Commonwealth versus Taylor. We have Justice Ginsburg joining Justice Sotomayor and Justice Kagan in a dissent in the Bluford case, saying, in ascertaining whether an acquittal has occurred, form is not to be exalted over substance. And they are making that point. I mean, I've done this for 52 years, and the procedures important to inform sometimes governs. And it's the recognition that double jeopardy is different. For instance, as I'll get to in the manifest necessity phase of the argument, all of the courts put a heavy burden on the prosecutor to justify a mistrial, to justify a re-prosecution. Ordinarily, I'm used to the burden speaking on me as a defense counsel. I'm used to having an affirmative obligation to lay out for an appeals court exactly what I want. But in this unique area, the disincentive to re-prosecuting somebody, the same prosecutor for the same offense, when there's evidence of an acquittal or evidence that the jury wasn't at an impasse over all counts, is so significant, it's so core to our values, that they put the burden on the prosecutor, and I will get to the cases that support that, what I call the central proposition, which is, where's the default? Is the default from not asking the jury about these other counts, that Ms. Reed goes to trial again? Or is the default instead that the prosecution simply cannot again re-prosecute her when there was not manifest necessity in the first place for the counts 1 and 3? The Supreme Court 67 years ago, I remember it because it was the tail end of the Warren Court. And it revolutionized criminal justice. And it talked about Miranda rights. Nobody knew Mr. Miranda back in the 1950s. Gideon gave right to counsel rights. Mapp v. Ohio extended suppression remedies for Fourth Amendment violations. These were all unknown until the Warren Court. The Warren Court, in the case of Green versus the United States, and it's in our pleading, said, and it's important, that double jeopardy was designed to protect an individual from being subjected to the hazards of trial more than once. That the state, with all its power, should not subject a citizen to the ordeal of living in a, quote, continuing state of anxiety, as well as enhancing the possibility that even though innocent, he may be found guilty by a second jury. So what do we do in a world where we have facts not known on July 1 that are known on August 8? And we're not, this is not completely novel territory. For instance, the First Circuit, the Federal Court of Appeals, it's 11 years since the Boston Marathon bombing. And they're still dealing because of capital punishment with whether the punishment should be life or death for the Sanaya that was arrested and survived. And they recently, in a lengthy opinion of over 100 pages, said, bring back these two jurors where we have a principal basis to question their impartiality. The SJC just 4 years ago, in a case dealing with a lawyer's allegation that there had been a racial statement, it's called the McCallum case, 485 Mass 790, said to the defense counsel, the judge will authorize you to recontact that juror and get an affidavit. And if there's any skepticism regarding the truth of the affidavit, we will have a hearing and make decisions. The nation was affixed to the Murdoch case from South Carolina, where a lawyer was accused of killing his family. And there was evidence recently, according to the media, that a clerk spoke to a juror, and the judge convened a hearing.
Quoting Murdoch.
Questioned the people who were connected to it before in order to make a decision.
Didn't see them.
In other words, regularly, judges who receive reliable evidence that there was extrinsic evidence that a marshal talked to a juror, was a juror biased, was the questionnaire fair, that something happened during that the jurors had accessed the internet when they were judicially prohibited from doing so. Courts reconvene hearings, and I can test that it can be done anonymously. It doesn't have to ineluctably lead to the identity of jurors. And we're going to ask the court to do just that, because without in any way diminishing the centrality and the importance of an impartial jury that tells the truth on voir dire, that's not ethnically or racially biased. There's nothing more central about making sure that jury was not influenced adversely by something from the outside or even by something from the internal discussions that reflected on a juror's racial and ethnic impartiality. But why isn't an acquittal entitled to just the same kind of deference? You know, we have not evidence that the jury was not impartial or that they were influenced externally. We have hard evidence that they reached a decision. We're not asking to have any inquiry, whether by counsel or by the court, into the content of deliberations, into their reasoning, into all of those matters that are forever private. But here we're asking them no more than Your Honor could have asked by polling them, which is, did you reach a verdict on count one? What was that verdict? What about count two? No. What about count three? Yes. So there is precedent, although slightly different.
He called her out.
No less important. To Your Honor making a decision. If Your Honor is skeptical in any way of the attorney's declarations, if you cannot accept them because they're not the sworn affidavits of lawyers, of the jurors, we authorize them to do what they haven't, which is to reinitiate a call to these 4 or 5 jurors, ask them whether they would read the lawyer's affidavits and affirm that they're accurate, or alternatively, authorize the lawyers to ask the jurors whether or not they would execute an affidavit. It could be 2 sentences. We reached a final decision unanimously.
That's it.
To acquit Ms. Reed of counts 1 and 3. Your Honor doesn't have to accept 4 out of 12 or 5 out of 12. Your Honor has a lot of discretion in terms of how to get to the bottom line, which is what is the truth here. Your Honor could schedule a hearing and have the 4 jurors in. They would remain anonymous. We will even waive public trial. I'm not sure that either of you
That's
would.
what I've been
But to keep
saying.
this private and keep this confidential, because we don't want the jurors to, risk identity. Your Honor could do it in any number of ways. We
These
have
closed captions
responsible court
killing me.
officers that can meet 4 jurors anywhere Your Honor selects. We have responsible lawyers and responsible prosecutors. This doesn't have to be an event that challenges the jurors' anonymity. I guess what I'm saying is that we're asking the court not through closing the door to this new evidence and really adopting a fiction that the impasse was on all 3 counts when we now know that there's strong corroborated, trustworthy evidence that was not, to establish a procedure consistent with McCollum, consistent with Tsarnaev, consistent with the Supreme Court decision in Renner, and take those cases where jurors do come in after the fact, when there's credible, responsible evidence that they were either biased or that they had some extrinsic evidence, whether from the internet or from an improper contact with a third party, and help us investigate this. I don't believe that if the Norfolk DA was convinced from that process, and it could be 4 jurors, it could be 12, but if all of them tell the court, we made a final decision, we never went back, like the Bluford case, or to re-examine it, it was not an intermediate decision, it was a final decision. All of our impasse was about count 2 and the multiple lesser includeds. I am hopeful that the prosecution would join with us in not seeking a new trial if they were convinced by these jurors under oath to what they've not yet been convinced by, which is defense counsel. This was a hard-fought case, and I'm not being critical of the DA, but I've done this for a long time, and I believe in our system of justice. People say it's not perfect, but it's the best that the world has. This to me is hallowed ground in a courthouse named after someone who was a friend who I deeply respected. I want the prosecutor to get the facts in the best way we can at this point in the case, which is through Your Honor. Order a hearing, Judge. Don't make Ms. Reed be the first person in the history of the Commonwealth to face re-prosecution for murder by the same prosecutor's office that tried her once and failed to persuade the jury she was guilty. They've not given a single case where facts like this have been ignored. Not a single precedent have they raised. Nationwide, state courts, murder cases, 50 states, federal, where there's been this kind of demonstration that we were silent when we shouldn't be, that she was acquitted. They've got the Commonwealth versus Juvenile, where there was a verdict slip, nobody knows when it was written. We have Bluford, but there was clearly further jury deliberation after a juror told the judge that we had reached a decision on 2 counts. I'm convinced, perhaps through many years of doing this, that acquittals count. And if she was acquitted, nobody wants her re-prosecuted on the counts for which she's been acquitted. And form's important, procedure's important, but what's more important is substance. What's more important is to find out whether that jury, in fact, voted to acquit and it was a final vote. And then I hope there's no dispute. I hope Mr. Lally will stand up in front of you and join me in asking that those 2 charges not be re-prosecuted. So let me switch from the acquittal and its implications to manifest necessity. In this case, we have explicit guidelines, which have been set out by the
I think
Supreme
she likes
Court
Marty.
that look to whether or not there was manifest necessity for the declaration of the mistrial. manifest is a word that says to show clearly. And whether the mistrial order was avoidable, whether there were any viable options, whether the court essentially had no choice, no options. And here at minimum, with 4 or 5 jurors saying, we believed her to be innocent, we believed there was a vote, there's no evidence from those declarations that there was an impasse on counts 1 and 3, an impasse that would have rationalized and justified the order of mistrial. The note, as I said, was believed to be unambiguous by the prosecutor, but in truth was ambiguous. It led to 1 or 2 constructions. So this is really becomes a burden of proof issue. Who bears the burden when there was an understanding by the court that the note reflected an impasse encompassing all charges, when we now know there was a rational alternative explanation for the note, a logical one, which is we were addressing only the charges in count 2, the multiple charges, the multiple decisions within the manslaughter count. Here's where the court helps us. The Supreme Court in Arizona v. Washington placed a heavy burden on the government, on the prosecutor, to justify a mistrial. The SJC has issued multiple opinions. And I'll read just a couple, because I think the burden of proof issue is central, Judge. Commonwealth versus Stewart, which goes back to 1985, and is one of the central decisions that started formulating the jurisprudence around double jeopardy and manifest necessity, says the prosecutor must shoulder the burden of justifying the mistrial if he is to avoid the double jeopardy bar. His burden is a heavy one, citing to Arizona v. Washington. Cruz v. Commonwealth, SJC 2012. The heavy burden of proving that a mistrial was due to manifest necessity lies with the Commonwealth.
Karen in her power suit.
Commonwealth versus Nicole, 452 Mass 816, 2008. The Commonwealth is unable to satisfy its heavy burden of proving that there was manifest necessity for declaring a mistrial, and the Commonwealth is therefore barred by the principles of double jeopardy from retrying Nickel. I have a copy of the Nickel decision because it's the one that was not referenced yet for your Honor's consideration. Nickel was an interesting case. It was a driving case, jury of 6. There was belief that one of the jurors should not be sitting.
It's a side note, and now because I'm going to pause and I have to leave a little commentary, guys. I can't just let it rip the whole time, even though I want to. This is great. I'm probably going to try and grab this as a thumbnail real quick, but yeah, let me just crop this real quick. But notice too, what color is Yanetti's tie right now? It's pink. It's pink. I feel like these are kind of spring colors, pink and blue, like that baby blue. It looks really good, but anyways.
Because he was a witness, if I'm recalling the facts correctly. And everybody considered it and thought there was no procedure to allow a trial to continue with a jury of 5. The defense counsel thought that, and the court thought that, and the court therefore declared a mistrial. Afterward, everybody discovered that this was in fact a rule of criminal procedure, and that defendants could waive a jury of 6 just like they could waive a jury of 12. And the court determined, as I just read, that there was no manifest necessity because there was a viable option to the declaration of a mistrial, that being the court could have asked the defendant whether or not they would agree to a jury of 6, but they didn't recognize it at the time. And then the court had a decision. Are we going to blame the defendant? Make them go to trial a second time in the face of double jeopardy's manifest necessity requirement? Or are we going to put the burden on the prosecutor to have advised us of that rule? This case is similar, Judge, because what you weren't advised of is Mass Rule 27B. See, everybody focused on Roth and Juvenile and Bluford, where all of them were single counts with lesser included. In the Roth case, the SJC decided that it prohibited judges like yourselves from inquiring into the vote. You couldn't ask the jury, well, if you haven't decided on manslaughter, what about involuntary manslaughter? What about OUI? But this is different because we have 3 counts, not 1. And Rule 27B that you were not advised of, and we contend, of course, the burden was on the table of the side that wants to re-prosecute her, says as follows. The judge may declare a mistrial as to any charges upon which the jury cannot agree upon a verdict, provided, however, that the judge may first require the jury to return verdicts on those charges upon which the jury can agree and direct that such verdicts be received and recorded. The advisory note is even more explicit. This rule also provides that the court may declare a mistrial in cases where the jury is unable to reach a verdict. However, it must first receive and record the verdicts which the jury can agree on. That rule, had it been brought to the court's view, provided a viable option to a declaration of a mistrial. It would have justified the courts, it would have required the court, as well as justified, to ask the jury whether or not it was an impasse on all counts, or rather than just one. So the Supreme Court not only puts the heavy burden on the prosecutor, it provides a set of guidelines which were established back by the Stewart case and repeated most recently by the Taylor case. And they even call them 2 principles guiding our review of manifest necessity. One is counsel must have been given, and the word must implies it as a mandatory, as an imperative. Quote, counsel must have been given full opportunity to be heard, and I'll address that second. And quote, the trial judge must have given careful consideration to alternatives to a mistrial. These are legal imperatives, and we contend respectfully, for a variety of reasons, that neither of those 2 guiding principles were met by the evidence of what occurred on July 1, where we have the chronology, if Your Honor, taking argument from counsel regarding the warning note, and the prosecutor didn't want a TUI instruction. Defense counsel did. Your Honor elected to give a TUI instruction. And 4 hours later, the jury sent a second note. And unfortunately, there was no convening of counsel and no request for counsel's position, no opportunity for Mr. Yannetti and Jackson to speak to Ms. Reed. After all, it's her rights, not just theirs. And there was this lack of consideration, careful consideration of Rule 27B, which the prosecutor failed to bring to the court's attention. Again, usually this would be an issue where the defense counsel could be criticized when they don't object to instructions after trial instructions. The Court of Appeals makes it very hard for appellate lawyers to succeed in reversing the judge's not providing an instruction that later they learn. But this is double jeopardy. This is different. This is why all of those cases, the U.S. Supreme Court in Arizona, the Supreme Judicial Court in Stewart, Nicole, the Appeals Court in a case, Commonwealth versus Oregon, we've cited. In light of the importance to the defendant the right to be free of exposure to second jeopardy, the burden of justifying the mistrial rests on the prosecutor. So again, it's the default. If these procedural guidelines, these principles, where the court must consider any viable alternative, just the judge may not know every rule at every moment, just like the judge in Nicole did. It's on the Commonwealth to have advised you, Judge.
Oh, he's going like full on
So
into
this
Commonwealth
was
law. No blame to Judge Bev.
a case that really comes down to whether or not there could be deference to a judicial ruling when it was made without meeting the criteria of full opportunity for the defense to be heard before the court read the final note and issued its final order, and a full opportunity for the court to consider the alternatives to the declaration of mistrial. I would say to Your Honor, that this is not easy. This was a long trial. Prosecutors had strong evidence that the jury was in fact deadlocked, at an impasse on count 2. The prosecutor has strong evidence that in fact the jury was not at an impasse on counts 1 and 3. They have to meet a burden of demonstrating to the court that they gave you all of the alternatives to the declaration of mistrial. And they should want, I submit, in a search for justice in this courthouse, where we don't want somebody who's found innocent once to face the second trial for the very same offense. That's the whole principle, centrality of double jeopardy. Justice Douglas and Black's words in Green. They should join us in asking the court to establish a procedure in Your Honor's discretion that either allows the defense lawyers to supplement the declarations with juror affidavits, or cut right to it, that the attorney declarations satisfy our burden of production. If Ms. Reed was acquitted, bring the jurors in, Judge, hear from them. Thank you. It's the right thing to do. Thank you very much.
Great, thank you.
All right. So that was Marty Weinberg. I'm just going to pause real quick because I want to make myself some coffee as we get to, I guess, the rebuttal, it would be called, where Lally or Miss LaGlaughlin, I don't know. I feel like Miss LaGlaughlin might be taking the reins on this one because I feel like she usually handles these matters when there's more of like an oral argument. But who knows? We'll see. But to quickly sum up, so what they were saying, and I personally felt like Marty Weinberg kind of like, I don't know. We couldn't see Bev's face the whole time, and I wish we could have seen a little bit more of a pan over here and there. I get why they were focused on Marty Weinberg. Of course, he's giving the argument, but there was a moment earlier, and I might pause, rewind back in a little bit as we get towards the end of this, where you can kind of see Bev like almost like give like kind of like a little smile, or just she looked a little bit softer in the face. Now, I don't know if that's just, I don't know, maybe she's in a better mood today, guys. Maybe she is happy that she got to it's Friday. She has big plans for the week. Who knows what's going on in the lady's mind, but I think Marty gives a softer kind of vibe, where I feel like David Gennady definitely balances out Alan Jackson's more pitbull energy, as I've described in the past. And then you have Eliza Little, who again also brings like that, more feminine and warm energy. I feel like Marty Weinberg brings the exact energy that is needed for this specific argument. And notice how he wasn't really placing the blame on Bev so much as to say, hey, you might not be aware of all the rulings, and that's not your job. That's not up to you. That's the burden of the Commonwealth to bring up these points. So I really think that was a smart strategic move, in my opinion, because based on Bev's rulings in the past, when it comes to the defense, it tends to lean more on the unfavorable side. We've seen a handful of times where, especially during like voir dire day, when David Gennady was arguing about, how they wouldn't, how could they prep these witnesses when you told them they couldn't, and this, that, and the third. So, and that got a little bit heated, and she had remarked something to the effect of, I don't need your hyperboles. etc. And you know how she feels about Alan Jackson for sure. So I think he was the appropriate person to handle these not closing arguments, excuse me, oral arguments. In this case, he seemed to, in my opinion, kind of butter up her up a little bit, citing back, to, oh, remember the good old days. And I'm not exactly sure how old Bev is, but she's definitely older, from what it seems like, than Alan Jackson and David Yannetti. So they have that kind of like generational thing in common. And I think that maybe there's a part of her brain. Again, I'm just speculating. I have no idea what's actually going on in her mind. But from what it appeared like in that quick little pan over to her, yeah, maybe she is reminiscing back on the good old days, when she was a prosecutor, when she was a former defense attorney as well too. Not recent article, but an article from when her days as a defense attorney has recently come up, which I'm going to pull up at the end of this video, because it's pretty relevant. Very similar situation with the case that she was defending at that time. So I don't know. I don't know how this is going to go. But I think that was really strong. And again, to sum up very quickly, so essentially, what Marty Weinberg was saying, he broke down everything pretty much that the Commonwealth was trying to argue, in their response, was that they started with the counts 1 and 3 charges because, again, that's the first thing that we want to nip in the bud. Then we want to work our way down to the lesser included charges where they were essentially deadlocked. And I think the biggest thing that came out of this oral argument, I think that it was a great amount of time that he took, quoting a lot of different case law throughout the country, which is great. Always helps strengthen the arguments. But him essentially saying that we don't care how you want to, like, confirm whether there's any merit to this or not. You can do it however you want to handle it. It's the discretion of the court, which I think Bev liked, not the fact that it came off more argumentative. Whereas in the past, if Alan Jackson came in, it would have been like, guns blazing, right? But I think she likes that, where it's like, no, this is your courthouse. Like, we're gonna respect that. However you want to handle it, we will accept that to the fullest. We're just trying to seek the truth in all of this, and we invite the Commonwealth and hope that they want the same thing too. We don't care how you want to pull this jury. Do you want to do it behind closed doors? Do you want to do it through signed affidavits? Do you want to do another hearing and close it off to the public? However you want to do it, we don't want to risk the anonymity of the jurors. We don't want to, expose them or dox them in any way, shape, or form. We don't want to make their lives more difficult. We understand why you ruled on extending that impoundment order. So I feel like a lot of, like, here and there, he was kind of buttering her up a little bit and making her feel good about her previous rulings. I don't know if that was a strategic move, but I feel like it kind of was. So now we're going to get into Lally's, or Miss McLaughlin's, argument. But first, I'm going to make myself a cup of coffee. So I will jump right back in 1 moment. All right, y'all, I am back. I had to feed my cat as well too. So, but now everybody is fed, everybody's good, and we're going to just dive right back in. In the meantime, before we dive in, let me just say, I want to give a shout out. I've been meaning to do this, and I apologize. I've been so crazy busy between day job and this job. But thank you, Dump Dog, for making your $5 super thanks from the other day. Really, really appreciate that. If you guys also want to make a donation to this channel, 20% of all proceeds will go to the Karen Read Defense Fund or another cause that we as a community are equally as passionate about. But because we are in the theme of Karen Read today, any donations that you make from this video, I will donate 20% of that. Share a screenshot and post it up on the community tab later today. What you could do is, the best way to make sure that you get the biggest bang for your buck is by scanning this little QR code, the very top. It's my top right, but if we're talking inverted video land like Yuri Buchanan, it would probably be the opposite. So however you're viewing this video, on the top right corner, you can scan it through your smartphone, or you could type it in via the URL link below, cash.app/$Alexis Room with an EW. And again, 20% of all proceeds will go towards the Karen Read Defense Fund, or you can become a member. We just launched that earlier this week. Kickstarter that. We have a couple different tier options depending on what your budget is and what you're looking to get out of being a member of this community. We have all kinds of special perks, including behind the scenes outtakes, which I'm going to be working on this weekend. Woo! Members only live streams, because as you know, with this channel, I generally don't go live for the public channel. But if you want to join members live streams, we'll be doing that 1 to 2 times each week for at least an hour a pop, just diving deeper into some of the latest and greatest stories we're getting into here on this channel, but as well as other cases you guys are equally as fascinated with. We'll open up those discussions as well too. I'm working on bringing on actually a couple of guests. Sorry, I have like a hair in my mouth and it's distracting. I'm working on getting a couple of guests on for those shows as well too. So if you want to be one of the first, make sure you hit that join button via the link below. You can sign up for as little as $5 a month. And what if anything, if you don't have any extra cash to invest in the growth of this channel, no worries whatsoever. Hitting that like button, hitting the subscribe button helps me just as equally as each of those things. So would really appreciate that. More importantly, Karen Read and the people whose stories we cover on this channel would appreciate that, because that means more people, the more the YouTube algorithm pushes this content out, and the more people can see and learn about Karen Read's story and continue to put pressure on these agencies. So with that being said, let's go back to court.
You want me here?
Wherever you.
Oh, Lally. You just tell she's like, "Ugh, okay, here we go. Here you go, honey."
Your Honor, Commonwealth would ask, request that the defendant's motion to dismiss be denied, as it was not a first term. Counsel had.
Here he is, looking down, reading out loud again. You know, it's just minutes before Bev is going to snap and be like, "Keep your voice up, Mr. Lally." But flat out the gate, unbeknownst to my surprise, the Commonwealth goes, "Yeah, we asked that this motion be denied, like completely denied." So, okay. All right. So this is where we're at. This is where we're at, folks.
An adequate opportunity to be heard and object to the declaration of the mistrial in this case, and the mistrial was declared as a manifest necessity. To that last point, as it applies to what counsel was referencing in regard to Rule 27B, what I would submit there is there's a stark difference between what Rule 27B encompasses and what counsel is asking for the court to do. And what I would say is there's a difference between what Rule 27B talks about, which is taking, or the right of a court to take partial verdicts, which certainly the court is entitled to do. If that were at any point in time indicated in any of the communications from the jury, or if there had been any communication whatsoever from the jury that they had reached a partial verdict. So Rule 27B has to do with taking of those partial verdicts, not inquiring or trying to extract or coerce a partial verdict.
Oh, there's that word again, coerce.
Declare repeatedly to the court that they're in an impasse. So simply put, Rule 27B just does not apply. When it comes to each of those respective points, the jury in this case, number one, did not return a verdict. Number two, counsel had adequate and ample opportunity to object to the declaration of mistrial. And three, that the mistrial was declared out of clear manifest necessity, which the court, case law, has repeatedly stated as the prototypical sort of evidence or example of what manifest necessity is. But to those points, it is backed by decades, if not centuries.
Oh, the sound cut out, Boston Sun. There we go.
Quite a twisting of logic into sort of a pretzel in order to have the circumstances of this case fit into the pretzel. Sort of there's quite a twisting of logic into sort of a pretzel in order to have circumstances of this case fit into the precedent. There's a reason for that, because there's clear and unequivocal precedent on each of those points that goes back decades, if not centuries. Commonwealth versus the juvenile is a case directly on point. And as the court is well aware, that's a case in which, following jury deliberations and defendant having been convicted after trial, one of the court officers found a verdict slip in the jury deliberation room in which the verdict slip was marked as not guilty. That case stands for the proposition that where those slips were in contradiction of the jury's report to the judge in open court, that they were deadlocked,
Wrestling those
that does not guilty finding on the verdict slip does not contravene or overrule the verdict as it is applied in open court. Quoting from that case, and I think it's directly applicable to what's been provided to the court so far, it states, it is not enough to show that the jury may have agreed on some issues at some time. If that limited showing were to control, uncertainties would be invited. And that's exactly what the defendant is asking the court to do in this case, is in contravention to that case law, in juvenile, in blue, in Roth, in Gray, in all of the cases over the decades and the centuries dealing with this. Blueprint itself states very clearly, the very object of the jury system, after all, is to secure unanimity by comparison of views and by arguments among the jurors themselves. A single juror's change of mind is all it takes to require the jury to reconsider a greater offense. And that also comes in Commonwealth versus Carney as well. But what it states, Your Honor, this jury was instructed, not only instructed orally for a lengthy time, but was provided with written copies of those instructions that the court gave that stated on at least 9 or 10 different times exactly what a unanimous verdict was and how to come to that unanimous verdict and how to report that unanimous verdict. And there was no verdict that was returned stating anything in this case. And in particular, the two charges that the defendant now complains of dealt with simple choice. There was a box for guilty and a box for not guilty. Neither was checked, neither was returned to the court at any point in time. There is no verdict in this case. Now, as far as whatever those communications that the jurors are referencing.
But didn't she say, but like, this is my whole point, guys, is like, didn't Bev say, like, not to check it? So I'm a little confused.
What the Commonwealth was here, Your Honor, is the jurors did nothing wrong in this case. The court did nothing wrong in this case. The court applied the law as it exists to this case. There's nothing special about this case. There's no special application or procedure that needs to be developed, created, or employed as it applies to this case or this defendant. This defendant, in this case, should be treated as any similarly situated defendant or any similarly situated case within the court system. These jurors, as the court referred to them as an extraordinary jury, and I know the court had opportunity to observe the jury throughout the course of the lengthy trial and to review the many communications that the jury submitted, which Commonwealth would submit, were thoughtful, were deliberate, were intelligent, were insightful. This jury told the court on multiple times that they had reached an impasse as far as their deliberations were concerned, as it pertained to the charges. In the final note that was submitted to the court, they referred to the charges in the plurality, twice within that note, as it pertains to exactly what they were saying. When it comes to what they were communicating and reporting to be at an impasse in regards, they refer to it as charges multiple times. Whatever point jurors may have felt, the other thing I would say about the jury is and this goes to the precise reason of why the procedures suggested by counsel are completely inappropriate in direct contradiction of what the case law says. I can't imagine whatever the jurors have undergone since July 1st, as far as extraneous influences, whether it's personal, professional, who they talked to, what they talked about, how those things have formulated in their minds. The intense pressure that they felt just looking at the affidavit from the one juror in regard to the comment that the court had allowed with reference to the jurors information remaining anonymous.
Wait, hold on. Am I getting this right? Am I hearing this right? Are they jumping back to the point that they made in their initial response where they were like, there's some level of coercion and this is completely unfounded, and because of these outside media influences and pressure from their colleagues and friends and family to come from. Am I hearing that correctly? I gotta back that the heck up. Like this, what? I gotta back this up.
On multiple times that they reached an impasse as far as their deliberations were concerned, as it pertains to the charges. In the final note that was submitted to the court, they refer to the charges in the plurality, twice within that note, as it pertains to exactly what they were citing. When it comes to what they were communicating and reporting to be at an impasse in regards, they refer to it as charges multiple times. Whatever point jurors may have felt, the other thing I would say about the jury is, and this goes to the precise reason of why the procedures suggested by counsel are completely inappropriate in direct contradiction of what the case law says. I can't imagine whatever the jurors have undergone since July 1st, as far as extraneous influences, whether it's personal, professional, who they talked to, what they talked about, how those things have formulated in their minds.
I mean, that's how it sounds to me. What do you guys think? Are you hearing that the same way that I am? That he's essentially claiming like these outside extraneous influences, whether it be professional from their professional life or friends, family, social media, etc., that's the reason that these ideas have formulated in their brains? Are they backtracking to that? Like, what?
It's pressure that they felt just looking at the affidavit from the one juror in regard to the comment that the court had allowed with reference to the jurors' information remaining anonymous, at least for the time being. With respect to that is exactly what the case law.
Are they saying like they're feeling pressured to come forward, or like they're afraid? Because I'm like so confused, like as to what he's trying to say here.
Advises against in government as far as taking this sort of post hoc weeks or months after a verdict has been returned or not returned, and then asking people to put themselves back in a position and indicate to the court exactly what was going on in that deliberative process. Asking them how they voted or what their vote was is infringing into that deliberative process that is specifically.
That's what they said in their
from any sort of point of contention or inquiry by counsel, by the court, at any point in time. When it comes to the adequate opportunity that counsel has to object.
Okay, so essentially he's saying by recalling them after a verdict, but there technically was not a verdict. Technically. There was a mistrial. They were deadlocked on the count 2 lesser includeds. Essentially what he's saying is to call them back in the weeks and months, a month after the fact would be infringing on their deliberative process. So like to elicit that information would be infringing on that, which is pretty much verbatim, quote for quote, what they stated in either their disclosure. I think it was their disclosure because they only filed twice. They had the response and then this notice of disclosure. So I believe this was in response to like a quote from the notice of disclosure of them speaking to, like quoting this back to one of the jurors who came forward to them.
To suggest anything else. This is the very first time that the jury gave any sort of note or indication beyond the first note asking for a report, Mr. Yannetti was asking for Arturo Rodriguez. And understanding that asking for Arturo Rodriguez is not equivalent to requesting a mistrial, it's the first step in that process, and experienced counsel knows that. And even in that first note, the jury had not indicated that their deliberations were done, that they had done thorough deliberations. They weren't asking anything. They were just reporting to the court simply where they were in their deliberative process at that point, reported to be at an impasse.
What?
Counsel.
Bro, they said they were at an impasse. Like twice. They asked for one like additional resource, the CERT report, I believe, and then maybe like one other thing, if I'm recalling properly. And then every note there following after was some sort of state remark that stated something to the effect of, we're deadlocked, we're at an impasse. What the heck else do you think that means? Like, to me, that I'm interpreting that as we're done. We cannot move forward with deliberations. We just don't know with the evidence that's been presented before us. We're at a crossroads. We're at the end of the road here. I don't know how else to interpret that, but apparently Lally's saying that doesn't mean that they were at the end of their deliberative process.
And these are Mr. Yannetti's own words on both occasions.
It's in your daddy's own.
From them, or argue for Arturo Rodriguez.
I'm sorry. Guys, I'm leaving these closed captionings up because it's hard to hear the audio. I've checked multiple streams. There's no mic on that podium, so it is hard of hearing, and I want to leave these closed captions up so you can get a little bit more of an idea of what they're saying. But I mean, like daddy's own, which I think is funny because if you follow Auntie Bev's long sigh on Twitter, she's they're always making just like funny different like memes, and it's like totally like a parody account where it's just like always making jokes about Bev's and Yannetti's like relationship, and it's just really funny. So it that remark right there, missing her daddy's own when they're talking about Yannetti, is really funny to me.
Indicated that from them, or argued for Arturo Rodriguez on both of those first two notes that came from the jury, that this jury was emphatic and that they were, quote unquote, hopelessly deadlocked. That is what counsel was asking for. What counsel is intimating there and making an argument about is for this trial at those particular points, or at least leading down. Now, as far and this is also, again, as I stated, backed by the cases. Ray versus Commonwealth states, counsel's request for Arturo Rodriguez instructions permits, quote, the inference that both parties were provided an opportunity to confer on possible alternatives to mistrial. Commonwealth versus Ferreira is on point with that particular point as well. And I think it's also important to consider this in the context of this particular case and this particular trial. This is counsel who was not shy, did not have any misgivings about presenting any sort of argument or any sort of argument against the court's decisions when it came to anything that was even a perceived slight measure against the defendant's interest, and I would direct the court to the verdict slip argument that was made post-trial as well. Getting to the manifest necessity, Your Honor, as I stated, what the case law clearly states is that a prototypical example of a manifest necessity is a deadlock or a hung jury. And that is what we have in this case. It's clear, it's unambiguous from all the communications, even Mr. Yannetti during his arguments for the Arturo Rodriguez recognized the same. The dangers of coercion when it comes to a deadlock jury are amply stated throughout the case law, as far as Ray, as far as Cruz. The court was never required and has never been required, and that goes from the Cooper decision from the United States Supreme Court, the Supreme Judicial Court of this Commonwealth, that there is no requirement that the court makes any sort of polling or has any sort of asking when it comes to those, how the jury stands, or whether or not they have a vote, whether or not they have a partial vote. I would also submit, Your Honor, that and that goes, the court was never required and has never been required, and that goes from the Cooper decision from the United States Supreme Court, the Supreme Judicial Court of this Commonwealth, that there is no requirement that the court makes any sort of polling or has.
So, and this has been like something that I've been like not really like actively fighting with people on Twitter about, because like I try and stay out of that crap. Like I said in my last video, you just cannot shake sense into some of these people. But this is like a big point of contention for a lot of people, is whether or not it is the court's duty to ask the attorneys if they want a jury poll. Whereas here he's quoting the case law, and I'm curious to hear the rebuttal from the defense, since it is their motion, what they have to say, if they have any additional case law to support whether or not. I mean, according from what I could see on Massachusetts law, on the government website, it's up to the court's discretion. So in that regard, yeah, they don't have to, but at the same time, I mean, like, why not? Why wouldn't you? And I don't know, because Bev was also the residing judge in the Michael Chestnut case, and there was initially a mistrial that was declared, and then I think they had a retrial, and he was ultimately convicted. The guy, I think his name is Emmanuel Lopez, who recently got convicted. So I'm curious if in that case, and if any of you guys know, please let me know in the comment section below if you followed that case at all, whether or not she did ask the attorneys if they wanted a jury poll during the mistrial. I'd be curious. So yeah, as far as I know, from the research I've done, it's not a requirement. However, at the same time, it's not, and this is what somebody, like some troll brought up, like it's not up to the court. It's not the court's job to do that. Well, it's not the court's job to do that. I mean, ultimately, again, as we saw in the Ashley Benefield case, Judge White asked the attorneys, once in that case, there was a verdict, not a verdict on all counts. Well, there was a verdict on all counts, but there wasn't a guilty vote on all counts. And he did ask the attorneys, do you want a jury poll? So, and again, granted, that's in Florida, different state, different laws, different courtroom, different judge, people roll differently. But if it's not her job, then whose job is it? And then everybody wants to say, well, the attorneys could have brought it up. Well, I mean, it's not their job though either to necessarily interject or bring that up. They are not required to speak up necessarily. So I always found that argument a little bit moot, but again, just going into this. So yeah, I mean, I guess that's a fair argument, but still, to allow the opportunity for the attorneys to say yes or no. And Mark Betterow, I believe, brought up a good point. In that moment, as an attorney, it could have been a strategic move. Of course, they're not going to voice that vocally in court, as to why they wouldn't want a jury poll. But because you don't know where you stand at this point, you're going to take the mistrial. You're going to take it as a partial win, right? It buys you more time to get things locked and loaded for the retrial. And I could see Yannetti and Jackson thinking, okay, like, well, what is the gain from, in this particular moment, pulling the jury? Like, we got the mistrial. Like, let's just leave it at that. And then after the fact, it was only a day after the mistrial was declared where the first juror came forward. And that was a juror, like, straight from the horse's mouth, coming to the defense, approaching the defense. So, yeah, at that point, I feel like they do have a right to get a jury poll. I think, why isn't that fair? Wouldn't you want to know, if you really are trying to seek real justice, why wouldn't you want to know what the the truth, what the truth is.
And so asking when it comes to those, how the jury stands, or whether or not they have a vote, or whether or not they have a partial vote. I would also submit, Your Honor, that counsel's argument is a little disingenuous when it comes to indicating that those cases only apply when you're talking about charges with lesser included, or charges that have a multiplicity of different findings that the jury can make. Because it ignores the fact that there are those two, and the two very charges or indictments that the defendant is seeking to dismiss here were very simple. Not guilty or guilty. Those are the two boxes to be checked. So in those instances, it may be permissible for the court to require a poll. But the coercion and the fear of that that's developed through the case law is inherent within the second count, which had all of those lesser included charges, which is exactly what the case law and the rules prescribe, as far as not allowing for the court to inquire into those types of scenarios. So, yes, the defendant's position is the court should have polled or inquired only as to indictments 1 and 3 and not to as indictment number 2. But again, I don't know if there's any requirement for the court to do that. I don't know exactly how the court is to do that when it comes to.
Yeah, they just suggested.
Polls.
Marty Weinberg just gave her a plethora of options. He said, I don't care how you do it. It's up to the court. It's not up to you how the court wants to do it, Lally. Bev can do whatever she wants. She wants to do another hearing, close it off to the public. Fine. You want to do it behind closed doors and change? I don't know. You want to do it via signed affidavit? So he just gave a list of options of how she could potentially do it. And I'm sure Bev knows how to do it and knows how, if she does want to go forward and poll that jury and bring him in, then yeah, it's up to her. She can figure it out.
The jury, while they're still deliberating. The notes and the communications from the jury, again, on 3 separate occasions, and very deliberately, as far as the language that was used, declared themselves to be an impasse on 3 separate occasions, the last of which included language to the effect that any further deliberation would be futile. That is the very definition of manifest necessity, and left this court with absolutely no alternative other than to declare mistrial. And it is clear from the language of the jury's communications report, and it's clear from the case law and the rules on the law itself, as far as what the court can do. The 2 areas that counsel is talking about and sort of asking for extension or creation of new law, again, sort of special or deferential treatment to this case or this defendant. The 2 areas in which the court can make post-trial inquiry have to do with some sort of bias, if there's an issue raised in regard to whether it's due to racial discrimination, gender discrimination, or some other protected class. So that sort of bias implicit in the jury's deliberative processes, or in an instance sorry, one moment.
Yeah, let's pan over to Bev. No longer. Now she's like frowny face too. And also too, like I like how Weinberg comes out with like a folder and like all these sticky notes and like printed text. Lally has like his legal pad, like yellow legal pad. It's just so funny. Oh, this is great. I gotta screen grab this. Sorry guys. Bev is just with these facial expressions, you can tell she's had enough of Lally. I feel like, and let me know what you guys think. Do you think Miss McLaughlin should have taken the reins on this? I do. I feel like she brings a little bit more of an energetic energy, and it makes it easier to follow along. Whereas Lally just kind of drones along, as Mark Betterow likes to say. He sounds like a dial tone.
And in an instance,
Mom is Lally.
There's some sort of allegation or some sort of evidence of extraneous influence. The defendant's not raising either of those issues. specifically within those cases, what the court states, which is obviously binding on your honor, is that those carve-outs for extraneous influences or bias on the parts of the deliberating jurors are permissible areas for post-trial inquiry. What all those cases also say is any inquiry into the deliberative process or exactly what counsel is proposing here is specifically prohibited by those cases that have developed over the decades. Commonwealth versus Moore states specifically that Massachusetts continues to adhere to common law principles barring inquiry into the contents of jury deliberations and any impeachment of jury verdicts based on information gained from such inappropriate inquiry. Now, the reason that the Commonwealth did not respond directly to the jurors when they came to them expressing.
Oh, this is good. Oh, this is good. I can't wait to hear what he has to say about this. I mean, I know like they already said what they said during their notice of disclosure, but just hear him verbalize this and articulate. I can't wait.
Wishing to have discussions about their deliberative process or their votes is specifically for the Rule of Professional Conduct 3.5C states specifically that inquiries into those topics are not allowed. The case law that is derived around that and since that corroborates. Simply because someone called you first does not then allow for that inquiry to occur. So whether or not you initiate the call to the juror or the juror calls you, it still does not allow for counsel or the court to then have these conversations with these jurors that delves into their deliberative processes or their deliberations.
But that's why we're here, Lally. That's exactly why we're here, so that Bev can say, yeah, you can, let's call him in. Let's call him in for a different hearing. Let's close it off to the public, or let's get each of them to sign an affidavit directly themselves, confirming that this is the truth. This is why we're here, Lally.
The specific type of coercion that is feared by the courts when it comes into this
Coercion.
Sort of condensed quote from Commonwealth versus Law. And it states simply, one cannot assume from the mere report of deadlock that there is any final verdict lurking within that deadlock that may be extracted. Such inquiries of the jury may succeed in extracting a partial verdict, but we could not have confidence that that partial verdict was the product of a thoughtful and thorough deliberation process. The risks of jurors' coercion are too high, and the reliability of any such partial verdict returned is too low to warrant such an approach to salvaging some partial result from a deadlocked jury. Simply put, Your Honor, what counsel is proposing as far as what the court should do is prohibited by the rules, it's prohibited by the law, it's prohibited by the development of case law over decades and centuries as to what is permitted. Certainly, the Commonwealth or anyone who wants to try someone who has been acquitted by a jury of their peers or retry them on the same case. That's not what happened. There was no verdict returned by this jury. Counsel had more than an adequate opportunity to address the court in relation to the declaration of this trial. And the court did absolutely nothing wrong in finding a manifest necessity as the only alternative that could have been employed in that particular instance. Polling the jury then, polling the jury now. It's simply not permitted by the rules, it's not appropriate, and therefore the defense motion should be denied. Thank you.
Can I reply,
right.
please? Thank you.
Okay, so there's that. I mean, he was pretty much just verbatim. He might as well have just read what that initial response and notice of disclosure said, because it was pretty much word for word. Quoting a lot of the same case law as well too, with his yellow legal pad. He kept flipping through. I don't know if that was him rustling the papers or if that was somebody from the NBC Boston 10 news crew, but that was like very distracting for me. But okay, so now we have what? Just, I don't know if they're still. Oh yeah, we might be able to catch up in real time, guys. So now we're gonna hear from Marty Weinberg again. But to quickly sum up, so Lally, again, just maintaining their initial response is not so much of this is hearsay anymore. They're no longer claiming that, but now they're saying that essentially it's not right to infringe on these jurors' deliberative process since it's been weeks since the mistrial was declared, and that the defense had adequate time to ask for, I guess, essentially some sort of jury poll before the jurors were let go, and Bev ended their service and declared the mistrial. So we'll see where this goes from here. I'm sure Marty Weinberg's gonna take the podium again. Yep.
There were two cases that Mr. Lally relied on, and they both stand for very different propositions of law. Commonwealth versus a juvenile, it's actually juvenile versus Commonwealth at 392 Mass 52, 1984. Says the judge was under no duty to inquire as to the status of the jury's deliberations on each of the lesser included charges within the murder complaint. Footnote 1 of that opinion says, quote, "We deal here with a complaint charging a single murder, where a complaint or indictment in multiple counts charges multiple crimes, e.g. 2 separate murders. A general verdict could be returned as to one of the counts, despite deadlock on other counts."
Oh, she nodded her
Commonwealth
head.
versus juvenile was as if count 2 in this case was the only count, and they discouraged any kind of court questions as to where the jury stood on lesser includeds. And that's the principle of Commonwealth v. Roth, the other case that Mr. Lally referred to. That case created a dichotomy.
You see that, guys? Bev's doing a lot of nodding here. Now, again, we didn't see a whole lot of Bev during Lally's oral arguments. And I wish that maybe some of the other streams, the other channels that are streaming this live from the courtroom, are capturing more of her reactions. But this is why I feel like she kind of likes Marty Weinberg. I feel like he's probably was the best person to present these arguments for. She's nodding her head. She's saying, "Yep, I know exactly what you're talking about." So interesting.
Where the court was asked whether or not a judge was permitted to ask the jury about lesser includeds, and because of the fear that a court's mere question could have a kind of domino effect in coercing jurors to reach compromises as to lesser includeds, the court prohibited such questioning as to lesser includeds. But the court distinguished throughout this lengthy SJC opinion. Our case, we're not dealing with one count vertically with multiple charges, we're dealing horizontally with 3 separate charges. Both Buford and the juvenile had evidence that the unanimous verdict that the defense was claiming occurred before the end of deliberations. In the juvenile, I think weeks or days later, a court officer found some verdict slips. Nobody knew when they were written. In Bluford, the Supreme Court case, where there was a statement to the court that we've reached a decision on one count, the court sent them out under Arkansas law because they hadn't decided, just what they needed to decide all the different allegations within a single charge. And they came back and said, we're deadlocked on everything. But there's no risk of jury coercion when a court is asking the jury whether they reached a verdict on other charges other than the one they were deadlocked on. There's no risk of jury coercion saying, does your note reflect all charges rather than one?
And I feel like that's a great clarification there too, because then you're essentially insinuating that the court is trying to coerce the jury into saying essentially what they want to hear. So I think that's a really good distinguishing point that he just made. You're essentially claiming that the court is coercing the jurors.
Your Honor instructed the jury, page 46 of the instructions, you should continue deliberating until you have reached a final verdict on each charge. We don't know whether the jury understood that instruction to mean that we can't come back and tell the court affirmatively that we've reached two decisions, two general verdicts, but we're in an impasse on a third one. The Commonwealth talked about the risks that some of the jurors might be exposed to media, and that's certainly more than true in the Sanaev case, where they've had, just an overwhelming amount of media regarding the catastrophe at the Boston Marathon in 2013.
Yep.
The government's investigation, the trials, jurors knew what one jury decided, and yet the First Circuit said that's not a prohibition about a court exercising authority to ask the right questions. Judge, you're an experienced jurist. I trust you to be able to determine whether or not a juror telling you they reached a verdict, to determine whether it was final or whether it was somehow influenced by the media. Your Honor does that every day when you pick jurors on the front end.
I love it. Like, he really is, like, he's buttering her up. He's saying, like, you're an experienced judge. Like, you've been in this game in law, practicing for years. You would know whether or not, be able to distinguish whether you believe it or not. I feel like he's saying all the right things to Bev, because that is what she wants to hear. She wants to be put onto this podium and being told and get a pat on the back for sitting in a chair with her name saying Judge Beverly Cannoni on the bench. So I think that's a good point. Like, you would know, because otherwise he's essentially insinuating like Lally is insulting you by saying you wouldn't know the difference between whether or not a juror has been influenced by outside media influences or not.
Determine whether they're biased or unbiased. It's certainly not a prohibition that should insulate an acquittal and allow a re-prosecution. The question at the end for the jurors would not be about the deliberative process. I understand Mr. Lally's citation to Moore and the discomfort and the rules that say jurors should not be asked questions by anyone regarding, why did the Commonwealth not persuade you that Ms. Reed was guilty? Or what did you think of this witness's credibility? Or why did you vote a certain way? Or what did the other 11 jurors say? A deliberating jury is not a focus group. It's not a place, for lawyers to ask about the views of 12 jurors, through the interview with one juror. But Your Honor is being asked to do no more than ask them what you would ask if they came out and said we had a verdict, which is, did you unanimously determine as a final determination that Ms. Reed is innocent of counts 1 and 3? Was your decision unanimous? Did any juror dispute it? That's very different than probing the subjective state of mind or probing for what other jurors said that caused somebody to reach that unanimous verdict. If Mr. Lally's concerned it wasn't a final verdict, Your Honor can ask the question, was it a final verdict? Was there ever a deliberation again after you reached that unanimous decision?
That was a great way to sum up everything Lally was arguing, is by saying we're not asking to get into, because this was essentially what they stated in their notice of disclosure, because in their initial response they were like, this is all hearsay, how can you even prove this is true, etc. So in their notice of disclosure, what they had communicated to these alleged jurors that came forward to the Commonwealth saying the same thing, confirming that, yeah, we acquitted on counts 1 and 3, and then count 2 was where we were deadlocked. He's saying we don't care. We don't care why they voted this. We're not probing into that none of that information matters. It doesn't matter if you thought Jem McCabe's testimony was credible, if Colin Albert's testimony was Mr. Bang Bang, his testimony was credible. They're not even asking, they didn't even bring up, and if you notice, it was in the affidavit in that text message exchange, which we went over in my last video. I'll link it in the description box below, from informant C, who was going back and forth with intermediary C, who spoke to one of the deliberating jurors about the trial, about their experience, what they voted, what went down, etc. And what they had said was that they felt intimidated by Brian Higgins on closing arguments day. And as we know, Brian Higgins was not in the courtroom on closing arguments. So who else is a big gorilla looking guy that is similar in stature to Brian Higgins and another Brian Albert? So they didn't even know like which witness was what at that point anymore, which is insane to me, because you would think that, after a serious trial like this, but because there were so many witnesses, it's probably hard in their brains to keep track of who was who again. Oh yeah, like wasn't Brian Albert the one who texted this to Karen Read and this, that, and the third? So I could see there was a lot of confusion beyond just the verdict slip form. It was just in terms of tracking witnesses and keeping track of who was who and who said what. So, but that's not the point of this. That is not the point. We don't care about that. We don't care about how they felt towards somebody, how they feel towards Karen Read, how they feel towards the Sallyport inverted video. We're not asking about that, or how the pieces of taillight revealed itself days later after the fact. We're not asking about any of that. All we care about, and like he said, you can even boil this down into 2 sentences by asking simply, can you confirm that this was the jury split? Cool. Was this a final verdict for you on counts 1 and 3? Were you at your end of your deliberative process for counts 1 and count 3, and you were ready to acquit? Cool. Awesome. Have a great day. You can go home now. It really, like, you don't need to get much more information out of them. So I think that's a really good argument against what Lally was saying about, it's not ethical. It's this, that, and the
In
third.
terms of the argument about Tui and Mr. Yannetti saying, well, they're deadlocked, if he wanted the mistrial, he could have asked for a mistrial. Then Your Honor would have, of course, had the discretion to deny it after 4 or 5 days of
Good point.
deliberation. He asked for a Tui instruction. And it's inferred by a Tui or a Rodriguez instruction in the state court. Tui, I think it's a 19th century federal case, is that you have hope when you're asking for the Tui instruction. My experience, usually the prosecutor who's confident in the jury that wants the Tui instruction to try to get the majority to overcome the minority and get to a guilty verdict. Here you have the defense lawyer asking for a Tui instruction, reflecting that he wanted further deliberations.
Yeah, and the
So
Commonwealth
there's
did
no
not.
answer, and the Ray case does not say that when you ask for a TUI instruction, you are really asking for something more than a TUI instruction. TUI means, I want this jury to reach a decision. And that's what Mr. Yannetti was saying during those 2 colloquies on the Friday before and then on July 1. We're not asking the jury to impeach a verdict. We're not asking for an inquiry that would be prohibited. I know the federal rule is 606B. I think the state number might be about the same way in terms of asking the jury for their state of mind. We're asking the court to conduct a voir dire that Mr. Lally agreed would be done if our argument is one of the 12 jurors was biased. If our argument was, well, we now have new evidence one of the jurors read on internet. We have evidence here that the jury acquitted Ms. Reed. What can be more central to the core values of our criminal justice system than to make a judicial determination with a respected and experienced superior court judge, whether that's so or not, and if it's so, stop her re-prosecution, because that would be a horror to make her convince 24 jurors of her innocence a second 12 when she's already convinced the first 12. Thank you, Judge.
All right.
Any responses to Larry or you all set? All right, thank you very much. I'll take this.
All right. So Lally doesn't have a response to that. I think that was a really strong rebuttal argument from the defense and from Weinberg, essentially just summing up the crux of what the Commonwealth's reason for not wanting to investigate into this further. Again, just to quickly recap, so saying we don't care as to what the jury's state of mind was. We don't need to know that. All we're asking is a simple, 1, 2, 3 question from you, the judge. It can be done however you want it, however you want to do it. It's totally up to the court's discretion how you want to conduct that. But it's essentially not fair to Karen Read. And what does that say for the rest of our criminal justice system, that this isn't stuff that we should take seriously? And that if this does happen again to somebody else who is also factually innocent, that they're going to have to go ahead and face another set of 12 jurors and do this whole thing all over again when the Commonwealth didn't meet their burden. So really curious to see what Bev has to say after this. So yeah, like I said, Commonwealth is not going to respond. They said their piece. I was a little shocked at that. I thought that Lally was going to come back, but I guess he feels like he said all that he could. I guess he doesn't have any other case law to support his argument. But I thought the defense did really well. I thought Weinberg, I don't know, maybe he could have won her over. Who knows?
Thanks, Judge. Judge, when I hand the Nicole case to your Honor.
Sure, thank you.
Foot rise.
All right. Goodbye. Karen Read looks, and she looks good. She looks happy with how things went. I thought Marty Weinberg killed it. I think he did a great job. She looks confident. She looks happy. Lally, not so much. Walks away, head down. There's Turtle Boy in the background. Curious to read his tweets, what he observed, which we'll get into now. So Bev is going to take this under advisement. I don't know if she's going to come back or if this is it. No, it looks like the stream has ended. Her family looks happy. Everybody looks confident. So I don't know. I don't know. But I want to hop over quickly. It's nice to see everybody kind of in good spirits and hopeful. We see some people wearing pink over here. David Yannetti, like I said, he's got his pink on. Let this roll for a couple more minutes, see if anything. See if we can hear anything. We did the press leaving. So, I mean, did she say when she was going to come back with the decision? Like, she just said, hey, I'm going to take, I want to play that back really quick.
Judge, when I hand the Nicole.
All right, thank you very much. I'll take this under advisement.
Thanks, Judge.
I'll take this under advisement. Like, okay, when are we going to hear back, Bev? Like, do we have a timeline? Are you going to come back today? Like, or are you going to come back at a later date? Are we going to, I don't know. So I want to, I'm going to pull up that article in a second about Bev, but I want to go to Twitterland and see what Turtle Boy's been tweeting since he was actively in the courtroom. Maybe we can get some shots of Karen walking out of the courtroom. If there was any interviews with Yannetti, with Weinberg, that would be great as well too. So I'm just going to pause this really quick and do a little bit of digging, and I'll be right back. Okay, so we got some good tweets from Turtle Boy. That's what I was saying. That's what I was saying. Auntie Bev never looked at Alan Jackson or David Yannetti like this. And that's why I'm inclined to agree. Backwards from 10, that's funny. It's always been obvious that what offends Auntie Bev about Alan Jackson is he's a showman. He's very effective and incredibly smart. Without him, we wouldn't be here right now. But the fact of the matter is that Canoni hates him and took it out on Karen Read as a result. She clearly likes Marty Weinberg, and this is exactly what I was saying, guys. Like, she likes him, and like he's a Massachusetts boy. He's not from California. You know, he's well known in the state. I think even Peter Tragos's father said that he went up against him in some kind of trial. But yeah, I mean, we even saw her reaction to Lally when he was done with his argument. So I don't know. This could, but again, I mean, you know, this could go any way. The camera isn't showing Judge Canoni. The way she's looking at Marty Weinberg is very different from how she looks at Alan Jackson. Weinberg is one of the most prominent defense attorneys in Boston and has been for decades. It's obvious she respects him because she's listening to every word and letting him talk. Very different dynamic than her and AJ. Yeah, and she didn't interrupt him. None of that. Yeah, he brought up the Alec Murdaugh stuff, which we heard, and I was like, wow, I didn't expect to see that one on my bingo card. It's like, yeah, even Alec Murdaugh, even he got a post-trial hearing after he was convicted. Yeah, with Becky Hill, the clerk. They all confirmed that they weren't influenced by her. Why is the Commonwealth afraid to pull the jurors? Exactly. So yeah, it seems pretty in line with what we were saying. I didn't know this because I was obviously covering this with you guys, but Jem McCabe arrived, which is unbeknownst to my surprise. I mean, like, but where are the Alberts? Where are the Alberts? Where's everybody else? Oh, because Jem McCabe was such good friends with her longtime friend, John O'Keefe, right? Smiling, pretending she's happy with her life. She hugged all these trolls. There she is. I mean, it's just it's wild. It's wild. You got Kate Peter slamming down a beer. This is more shots of Jem McCabe. He's wearing like that shirt is way too big for you, girlfriend. Adam Lally says the jury repeatedly communicated to the court. Yeah, this is exactly what I said. They just didn't say they were at an impasse on all three counts. Exactly. But they said that they were at an impasse. And that's enough to say that, for me, in my opinion, that they are done with their deliberative process. But again, the question is, what were you at an impasse of? And I think we have every right to know. We don't care what their state of mind was. So that's from Turtle Boy. Let's see if there's anything from like Tom CPU. Just in like some of the post. I don't know, is he even on Twitter? He might not even be on Twitter. Let's just go. But I mean, I like how she didn't even say like, hey, we're gonna be coming back. Like, are you coming back this day? Like, she didn't say any. So I don't know. Is she gonna come back? I don't know. Is there anybody on the way back 35 minutes ago? Let's see. Yeah. Sorry, guys. I just want to make sure. So, let me see.
Yeah. And like, I guess I bet you he's recited that same case law in other, other trials. I guess he's like, wow.
Ali, on the other hand, any pre-trial motion. Excellent.
It's on stage.
There's Turtle Boy, TB. It like really is like the North and South again. I feel like this is like another civil war. So
That's
there we go. There she is. Family, Yannetti. Yeah, she looks good. She looks confident.
Nice. I don't know, but that was a good move. I like that. You see that? Out of the way.
Karen's mom. Turn this down a little bit.
Good job, Dan. Good job. Good job, Ronnie. Are you gonna move? Let's go. Let's go. Keep moving. Let's go. John. Let's go.
Yeah, I want to know who that cop man is.
You don't need to. I got it.
Weinberg's.
A little glitchy there. So let me see if I'm just gonna stop sharing. So that was got them all going. Let me see if Boston 10 posted any updates of her outside. Yeah, it doesn't seem like anybody. I'm sure we'll get some more stuff. Let's see if LTL. Otherwise, I'll get into. Let's see. Just want to see if. Well, no. All right. So if I. What? Where am I going? Where on earth am I going? Oh my gosh. I have like way too many tabs open. Okay. So. Yeah. So I want to go through this article. I thought I saved it. Maybe I retweeted it. Somebody posted it earlier today. One moment. So this was shared. I think this was shared by a couple of people, but this is the one I saved from 1990. Shared by True Crime with Eve. And thank you, Eve, for sharing this with I'll give her a follow. Please give her a follow for sharing this. But yeah, so Bev was a defense attorney for one of four men, then charged with 2 counts of rape and assault and battery. Jury convicted all 4 on the lesser charge of A and B. So assault and battery. She challenged this. Her argument to the judge, confusing instruction by the court. So really interesting. Remember, Bev was a prosecutor. Then I guess she became a defense attorney, and then I don't know what else she did, what else her resume has, but now she is a judge. So this little snippet of the article says Beverly Cannoni, Matthew Simcox, attorney, argued that the jury's verdict was clearly against the weight of the evidence because no one denied that there had been sex, and the jury found that there had been no grape. Cannoni said this indicated that the jurors accepted the defense of consent. Thus, the lawyer argued the finding of indecent assault made no sense and might have been due to confusing instructions by the court. Judge Patrick King stayed the sentences while he considers defense requests that he set aside the verdict or entered a finding of not guilty. But I mean, this is like totally different case. Just to pull it up for you guys. Totally different case, but how ironic. What, 30? That's 30. Oh, no, 40 years ago, right? No. Am I doing my math correct? Am I mathing correctly? 30 years ago. Over 30 years ago. Very similar. So, this is her from the good old days. Same haircut. Same frown. But it's interesting. It's interesting. So, there you have it. I don't know what's going to happen. I don't know when she's going to rule. Again, I'm going to go check out a couple of additional streams in the meantime. And as soon as we get an update on her ruling, I don't know if it's going to come back later today. I don't know if she's going to call for another hearing. I don't know. I don't know if she's going to come back with like some kind of, well, I imagine she's going to call him in at some point. Who knows when? It's Friday. You know, she likes her weekends. So we'll see. She's probably already halfway to the clam bar. Hopefully she does the right thing. But from her reactions to Marty Weinberg, I mean, I think this could, at the very least, her granting permission for both parties to elicit and for the court to elicit what the jury split was. Taking a jury poll. She will probably do it in a closed courtroom. That's my opinion. I don't know if it'll be streamed. I don't know, but we will see, and we will keep you posted here on Alexa's Room. But thank you so much for watching. And if you enjoyed today's video, make sure you hit the subscribe button. Make sure you hit that notification bell so you don't miss when Bev comes back with her response. And make sure you leave a comment too, because it helps again with the YouTube algorithm and pushing the story out. And like I said, as always, hit that like button too. You know, if you don't have anything that you want to say, no pressure to leave a comment, but I would love to hear your thoughts, opinions, what you think Bev is going to do. Do you think that she kind of took a liking to Marty Weinberg? Do you think she's going to rule in the defense's favor? Do you think we're going to get a jury poll? Excuse me. Let me know in the comment section below and hit that like button, because again, the YouTube algorithm loves that, loves when we do that, and it just, oh, we got a cat. We got a cat coming in. So YouTube algorithm loves that, and it makes sure that this story reaches more and more people. And the more people that hear about Karen Read's story, the more pressure we put on the DA's office to do the right thing and ultimately dismiss all charges, because this is just bogus nonsense that does not need to continue on. And the taxpayers of Massachusetts do not need to continue to essentially pay for this circus show of a trial. So, oh my God, I'm getting yelled at by my cat. But with that being said, I'll see you guys in the next video.